Please, Your Lordship, I'm still dealing with the interpretation of Article 32. And the submission of my learned friend Lord Goldsmith for the present trustees was that Article 32 has not changed the English common law position. So the third-party creditor can only go against the trust fund indirectly through the trustee's right of indemnity. And if the trustee is in breach of trust, then the creditor's position remains as prejudiced as it was under the common law in England, because if the trustee hasn't got a right of indemnity because he's in breach of trust, then the creditor can be in no better position. So the effect of Article 32, according to that construction, is that the creditor is worse off than in England, because not only can he not bring a claim against the trustee personally, in his personal capacity, he can only bring the claim against the trustee in a representative capacity. He has still also, as a creditor, got all the problems of getting at the trust property as a result of the old English common law rules that found in Re Johnson. And those rules apply whether the trustee whether the third party knows that the trustee has committed a breach of trust or doesn't know it. My Lord, we say that if one looks at the language of Article 32(1)(a,
just say, why is the creditor worse off?
because he can no longer bring the personal claim against the trustee.
So under A, it's A, basically.
Yeah.
You can't have recourse to the trustee's personal assets.
Exactly, exactly.
So it's simply A, which on the face of it is not looking at the creditor's position, but is intending to put the trustee in a privileged position.
My Lord, what we say is that one has to look at the position not only from the perspective of the trustee, but also the creditor.
And the beneficiaries, presumably.
And the beneficiaries. And we will look at each of them in turn here. As regards the creditor, he is told by the section that his claim extends only to the trust property. Now, it doesn't say, and this we submit is crucial, it doesn't say his claim extends only to the trust property less the amount for which a trustee may be liable to account to a beneficiary for breach of trust. So, as far as the creditor is concerned, what he's intended to be able to do is to assert his claim against all the trust property without any reduction flowing from any breach of trust by the trustee.
So how does this work in practice? You take a decree against the trustee as trustee, and how do you get access to the trust fund?
I didn't catch the first word. If you
So
take
you take a decree against the trustee as trustee.
Yes.
And then how do you access the trust funds?
My Lords, in practice it works this way, as will happen in this case. There is a judgment against the former trustees for £80 million and 78 million euros converted at the relevant date plus interest. It will then be necessary to seek to execute. And the execution will take place by looking to the trust property. It will be necessary, as is proposed in this case, for there to be an application under Section 69 of the Guernsey Trust Law. We'll come to that in a minute. There's an equivalent provision in Jersey, in which it will be necessary for the court to deal with the claims of competing creditors on this trust property. because Thorson and Glenalla are not the only creditors of the TDT.
So what, administration action?
My lord, yes.
Is that the only form of enforcement?
Well, under administration action, all sorts of orders can be made by the court.
But you say that, and is that going to be the invariable gateway to a creditor, or just the gateway in this case where the trust may be insolvent as against the debts?
Subject to the expert opinion on the left, I think it's the only way, yes.
Right.
Yep. I will be corrected later on if I've got that wrong, but that's my understanding. It will be necessary for the court to make orders how to deal with the remaining trust assets, which are worth very much less than the 200 million plus, which is now due just under these judgments. So, Lord Hodge, I hope that explains how, in practice, the...
Yes, so whether the trust is solvent or insolvent, the mechanism would be an administration action, is that right?
My lord, yes, I think it would be. Yes.
It would be. That's what I wanted to know.
Yes.
Thank you.
And what is the status of the creditor? He's a creditor in the administration action? I mean, what's his status vis-à-vis the trust property?
My lord, there is, when we come to the Guernsey rules, and there are similar ones in Jersey, he has a right to apply to be a party to make a claim in the administration action. In that sense, there's an analogy with the position in England, where you have an administration of an estate, personal representatives have to collect in the assets, pay the debtors, and then distribute to the beneficiaries. In case of uncertainty, the creditors will be joined to that administration action to decide whether or not it's permissible, for example, to make distribution to beneficiaries, or whether all the how to deal with the competing claims of creditors, for example.
But it's one thing to be joined in an administration action as an interested party, but you're saying they would be the applicants in the administration action if the trustees chose not to help.
Well,
taking the view they're not personally liable, so why should they worry?
Well, in practice, trustees would want to know how to deal with their own. If the assets are in their hands, they would want to know how to deal with them, because obviously they would be vulnerable to criticism.
So I think you have to say, don't you, that the creditor would be entitled to bring administration action itself.
In practice, my lord, yes, but it would be with the permission of the Guernsey Court, law, Section 69. Going back to the interpretation of Article 32, we therefore say that the language of Article 32 does not suggest that the creditors' claims are going to be diminished to something less than the extent of the trust property as a result of the fact that there are liabilities of the trustee to beneficiaries. How does that tie in with the position of beneficiaries and the duties of trustees to their beneficiaries? In one sense, it makes no difference at all. The trustees remain personally liable to the beneficiaries for breach of trust if a breach of trust has occurred. Article 32 is not dealing directly with beneficiaries' claims. It's dealing, as it says, with third parties. Beneficiaries are not third parties. Beneficiaries' claims are dealt with by Article 30 of the Trust Jersey law, which is just a page or two back. I won't read it all, but it's, your Lordship's still got the legislation in front of you from this morning. It's on the previous page, and it describes the...
Afraid I've moved to the
I'm so sorry,
84.
20429, MS 20429.
Thank you.
But as one would expect, it's generally the beneficiary who brings the claim against the trustee, because the trustee's duties are owed to the beneficiary, not to anyone else. And that is a separate regime. And it's a separate regime from Article 32, which is dealing with creditors. And the striking thing about Article 32 we submit is that nowhere does it say that the third-party creditors' rights extending to the trust property are subject to claims by the beneficiaries in breach of trust. But if my learned friend Lord Goldsmith was right, one would have expected this to have been spelt out in the legislation. Because if the purpose was to preserve the common law position, it would have required clear words to oust what we say is the plain meaning of 1A. My lords, if my learned friend was right, my learned friend Lord Goldsmith was right, that Article 32 made no difference to the common law position, then it's not at all clear what 1B is supposed to be doing. It appears to be largely redundant. So, my lords, those are my submissions.
Simply because it reflects the common law position.
But then, why is it necessary to distinguish, in the case of the knowing third party, between the position of the ignorant third party and the knowing third party? Why is there that distinction?
Well, because in A there is no personal liability, and in B there is. And in B you can go against the trustee's personal assets subject to his indemnity.
I'm sorry, of course, but it was the further.
That's why it's there. But you're looking at the question down the line.
And I'm also looking in particular at the position of the creditor and yes. Why.
Well, your point is that that A represents the only thing that is different from the previous common law.
Yes.
Therefore, it's got to be sufficiently different.
Lord, yes. And we would say that if one thinks about what Jersey is trying to do, it's trying to make Jersey an attractive place to deal with, to have trusts governed by Jersey law, whether they're administered in Jersey or simply the law of Jersey is selected.
But that's normally a matter of choice by the settlor,
My lord, yes.
who might be supposed to have the interests of his beneficiaries primarily in mind.
But he might also be anxious to ensure that the trustees can transact with third parties in a way that operates fairly rather than unfairly as under the English system. It creates a much clearer regime, we would submit, than the English position, because the English position is bedeviled by the uncertainty that the third-party creditor had when dealing with a trustee, because he could not know whether the trustee was already in breach of trust, so that his claims against the trust property, indirect claims against the trust property, would be jeopardized.
Why isn't the only relevant purpose that we necessarily find? I mean, this law could have had all sorts of aims. One just doesn't know. It depends what your view of fairness is. Why isn't the only clear purpose the change in A so as to restrict the liability of the trustee to trust assets?
Well, because it goes further. It's dealing both with the trustee's position and the third parties.
Yes, but I
And
mean,
the
that's
third-
as against, restrict as against the third party. That's the one thing one can be certain of, and it seems to me, in order to go further, one probably has to be certain that or clear that it does some further things. Why does it necessarily do any further things?
Well, my Lord, we submit it does if one looks at the background and the contrast between the two. But
When you say the contrast between the two, we don't know whether they focused on what might be regarded as the undesirable elements of English law or not. The one thing what they made clear was that they wanted some sort of restriction on the trustees' liability, which is no doubt good for Jersey trustees.
well, it's part and parcel of the same issue, my Lord, which was the issue which has been, as I say, known to trust lawyers for a very long time, over 100 years. And we say they're really two facets of the same problem. My Lord, if I may, can I then go on to the appeal against the BVI company's appeal against the finding that Article 31 applies matter of private international law? And as your lordships will be aware, there's no previous decision on this issue in Guernsey or any other jurisdictions, as far as we're aware, as I mentioned to your lordship a month ago. Can I begin with a couple of basic points about private international law, which I know your lordships will be familiar with, but it's worth stressing. First, this is a matter an issue which falls to be determined according to the private national law's rules of Guernsey as the forum. And that is apparent from the two leading cases of Macmillan and Bishopsgate and Raiffeisen Centralbank. And we've included citations in our cases of the key passages there. For your lordship's notes, it's MS 14166 and going forward from there. So there are 2 pages of citations from Macmillan and Bishopsgate and from Raiffeisen about the process of characterization, the 3-stage process. And the first stage is to identify the issue that arises in the case. And the point is made in Macmillan and Bishopsgate that the applicable law is not found exclusively by reference to the law of the cause of action. One has to look at what the relevant issue. And in Macmillan, your lordship will recall, the cause of action was in restitution, and it was said that the relevant private international law that should apply should be the common law rules that identify what the applicable law is in relation to a claim in restitution. But the Court of Appeal held that that wasn't right. The issue was, what is the applicable law in relation to the defence? And the defence was bona fide purchaser for value without notice. And both Mr. Justice Millett at first instance and the Court of Appeal on appeal said one had to identify what was the applicable law in relation to that sort of defence. And so they found, as it happened, that it was the law of New York as the place where shares had been transferred and where the companies were incorporated. So it's not the law of the cause of action which is decisive. It's the law of the issue. And I said to your lordships at the beginning that our defence has always been this, that trustees accepted they were liable in a representative capacity. Their defence was that they were not liable in a personal capacity for the debts of Thorson and Glenalla. So the question is, what is the applicable law in dealing with that defence. Now, Lords, if one looks at the Trusts Law Guernsey, which is the law of the forum, in our submission it contains rules which identify the private international law rules which apply to a case of this kind. One finds the Trusts Guernsey law in Volume 1, tab 21, 20338. If you have 20339, which is just sets out the sections, it's quite helpful to see how they are grouped. I'll be coming back to this. Part 1 is preliminary. It deals with definitions of a trust, the validity, the proper law, and the jurisdiction of the court. They're of general application. Part 2 contains sections 5. Sorry.
Sorry, part 2.
So, still on page MS 20339. Part 2 contains provisions that are applicable only to Guernsey trusts. I'll come back to their content in a minute. Going over the page to 20341, you'll see Part 3, provisions applicable only to foreign trusts. And then Part 4, provisions of general application which apply to both Guernsey trusts and foreign trusts. Now, the provisions of Part 2 we'll look at in a minute, but can I just ask you to look at some of the definitions which apply across the board. 20342, Section 1, defines a trust. And your Lordships will see that it is defined by reference to property. A trust exists if a trustee holds or has vested in him or is deemed to hold or have vested in him property which does not form or which has ceased to form part of his own estate. So it distinguishes at the outset between personal patrimony and trust patrimony. And then it's held A, for the benefit of another person, a beneficiary, whether or not yet ascertained or in existence, and or for any purpose, other than the purpose for the benefit only of the trustee. So rather different to English law in this respect. First of all, because English law doesn't have a statutory trust of that kind, and secondly, you can't trust for purposes other than charitable purposes. Over the page, 20344, 2, not relevant, trust is valid and enforceable Guernsey. 3, the proper law of a trust. This is important. Subject to sections 51 and 57, which I think are about changing proper law. The law chosen by the settlor to be the proper law, the choice being expressed or implied in the terms of the trust. And that's our situation. We have a trust deed which chose in the TDT the law of Guernsey. Over the page, a trust, the proper law of which is the law of Guernsey, is referred to in this law as a Guernsey trust. An obvious definition. Then jurisdiction of the court, again, well, different to English approach to these matters, where in England we deal with them on the rules. The royal court, sitting as an ordinary court, has jurisdiction in respect of a Guernsey trust, so that's a Guernsey proper law trust, and any other trust, a trustee of which is resident in Guernsey, and that's the basis on which the matter was justiciable in Guernsey, because the former trustees were resident there. And then we have in Part 2 a series of provisions dealing with the law that governed Guernsey trusts. We're not suggesting that the law of Guernsey applied to the TDT, but the law of Guernsey and its provisions applicable to Guernsey trusts identified the sorts of matters which, under Guernsey trust law, are viewed as matters of trust law. It covers a wide variety of subjects, including the rights of beneficiaries, the duties of trustees to beneficiaries. But at section 42, it deals with the trustees' relations with third parties outside trust. And you find that on 20375. And your lordships will see that this, say, deals with trustees' relations with third parties, which is regarded as a matter dealt with by trust law in Guernsey, unlike, say, in England. So section 42, subsection 1, contains a rule very similar to that in Article 32, 1a, subject to subsection 3, where in a transaction or matter affecting a trustee informs a third party that he's acting as a trustee or the third party is otherwise aware of the fact, the trustee does not incur any personal liability, and a claim by the third party in respect of the transactional matter extends only to the trust property. So a very similar provision. And then 2 deals with the ignorant third party. Sorry, it sounds rather offensive. The unknowing third party. 3, nothing in this section prejudices a trustee's liability for breach of trust or any claim for breach of warranty of authority. So the rights of the beneficiaries are preserved as against the trustee personally, as in Jersey. And then 4, this is important, my lords, this section applies to a transaction notwithstanding the lex causae of the transaction, unless the terms of the transaction expressly provide to the contrary. So in this law, to answer a question which I think my Lord Briggs put to my learned friend this morning, it's made clear that you can have an express provision which contracts out of the section 42, but subject only to having an express provision to the contrary. The section applies whether the transaction is governed by the law of Guernsey, Jersey, England, or anywhere else. It's an overriding rule of trust law.
Well, that's a completely different rule of PIL to the one you're advancing, isn't it? You're arguing that there's something in these sections which affects effectively the status of the trustee. If he's known or she's known to be a trustee, then they can be regarded as sort of type of, to that extent, of having separate personality, whereas this is a conventional rule of proper law of the contract, treats it on an entirely different basis.
My Lord, it creates a rule of private international law, yes, I follow that. I'm sorry, I'm not sure I understood the first part of that.
Well, I thought your argument was that the Jersey Act, the Jersey section, didn't operate on the basis, at least in every respect, by reference to the proper law of the third-party transaction. On the contrary, it recognised that this was a transaction which was entered into by the trustee in a particular capacity, and therefore it's subject to the law governing capacity, which is the law of the trust. Am I wrong?
I will put it in a slightly different way, yes. My Lord. It's the point is that where a third party transacts with a person whose legal regime is governed by a statute under which he operates and created, is bound to accept that regime when he deals with him.
Yes.
I wouldn't say it's a question of capacity. It's just
So it's status, or anyway, you treat them for certain purposes not as if they're just an ordinary individual, but as if they had an element of personality separate from their personal personality.
I mean, if you treat the trustee as having two legally distinct personalities, it may be that you don't need subsection 4, because on that footing it's part of the constitutive law of the defendant, and that would apply internationally anyway.
my Lord has I've gratefully.
So it's not so much there's an inconsistency, but there's a redundancy if you are right on the effect of sub 1.
My Lord, yes.
Except, I mean,
It also,
your contention goes much wider than the Guernsey law, because the Guernsey law, subsection 4, means that it only applies if you're litigating in Guernsey, or alternatively, of course, if the proper law is Guernsey. But if you were litigating in England about a transaction affixed to law other than Guernsey, you wouldn't be able to apply.
well, with respect, my Lord, that's begging the question, isn't it? And that's the very issue which is before your lordships. I mean,
Yes, I know, but
yeah.
that's why you have to go further than this section would go. This section's
Sub
fine.
4 wouldn't help you in litigation in England, because
Right.
the PIL is governed by the Lex Fori. But sub 1, if you're right, would apply everywhere.
My Lord, yes.
On a different basis.
On a different basis.
Yes.
Yeah.
Lord, yes.
Well,
The moment I'm addressing your lordship not on the different basis, I'm just showing you.
But I
what
know,
they-
but I think what we're pointing out, or at least what I'm pointing out, is that it is a different basis, this, and it may not help you with your argument on the Jersey law, because it doesn't seem to view the matter in the way that you argue the Jersey law should be viewed.
My Lord, can we? The point I'm seeking to draw from Section 42 as a whole is this: that as a matter of Guernsey law, it views the question of the relations between trustees and third parties as a matter which is a matter of trust law, and it's part of the regime that applies where you have a Guernsey trust. It's part of the statutory regime. The statutory regime is not just about the relationship between trustees and beneficiaries in Guernsey. It's about the relationship between trustees and third parties too.
It's a Guernsey Trust.
Exactly, Lord, yes. But when one asks, in a moment, going forward, what it means, what Section 65 means, that, we respectfully submit, is an important pointer to what Section 65 means. Now, Section 65...
I mean, you deduce that simply from the fact that it's to be found in a statute relating to trustees.
My Lord, yes.
I mean, that may be a slightly slender basis for...
Well, it's a question of looking at the statute as a whole and asking what the statute as a whole means. And we then go forward, my lords, to 20390. Provisions applicable only to foreign trusts. In fact, there are only two provisions which are exclusively applicable to foreign trusts. My lords, a foreign trust is defined as one where the proper law is not the law of Guernsey. One finds that at Section 80 at 20400. I think it's fairly obvious from the context. So the TDT was a trust governed by the law of Jersey. It's therefore a foreign trust for these purposes. Section 65 says, subject to subsection 2, which is about abuse of law, a foreign trust is governed by and shall be interpreted in accordance with its proper law. And then it says a foreign trust is unenforceable in Guernsey to the extent that it purports to do anything contrary to the law of Guernsey. It confers or imposes any right or function to exercise or discharge which would be contrary to the law of Guernsey, or the royal court declares it's immoral or contrary to public policy. So none of those provisions are relevant here. Subsection 2 is dealing with preservation of Guernsey's own legal rules, preventing abuse. The question in our submission is this: what does it mean in section 65, subsection 1, to say a foreign trust is governed by and shall be interpreted in accordance with its proper law? Now, in the context of this statute, Part 2 of the Guernsey statute indicates what it means to be governed by the law of Guernsey. And we say that if one finds provisions of the same kind in the foreign law as are found in Part 2 of the Guernsey statute, then those are matters which fall to be governed by that foreign law.
So you submit that any provision that is made about Guernsey trusts in Part 2 must, so far as there are equivalents in the proper law of a foreign trust, be treated as governing that trust for the purpose of Section 65.
My Lord, I submit that they are the provision. I do, yes.
Why should that follow? I mean, there's a very large number of specific provisions relating to Guernsey trusts, naturally enough, since it's regulating trusts whose proper law is that of the law of Guernsey. Why should it be the case that anything which the legislation says about Guernsey trusts must be treated as falling within 65(1) as applied to foreign trusts?
Well, I'm not suggesting that it's referring to exact identity, my Lord.
Oh.
My submission is slightly different. It is this, that when trying to understand what the Guernsey legislature means when it says a trust is governed by Jersey law, foreign law, the proper law of that foreign trust, one can look for guidance as to whether or not a matter in the foreign law is something that governs the trust by reference to what the trust's Guernsey law says about Guernsey trusts.
You're right about that. It would follow, would it, that if there's nothing in Part 2 about some aspect of trust law which a foreign trust law does deal with, then somehow it's not governed by it for the purpose of Guernsey. Well, I'm thinking, for example, of the rule against perpetuities, which I don't know whether it's in Part 2 or not. I rather suspect it isn't.
I don't think they have a rule against
right.
perpetuities.
But if the trust was governed by English law, it would be subject to a rule against perpetuities. Now, that would govern, in circumstances to which it applied, the validity of the trust.
My Lord, yes.
But it would do so because it was part of English trust law, not because there was some mirror provision in Part 2 of the Guernsey trust law.
My Lord, I follow that argument and I accept it. But the point I'm making is with respect to a slightly different one. The question is, what are the sorts of provisions that the Guernsey legislature views as provisions which govern a trust? And in your example of the perpetuity rule, yes, that may be a rule which governs the foreign trust. And that the Guernsey court is likely to respect that. But my point is that if Guernsey itself has a rule in its own trust law, which is akin to that in a foreign law, which in Guernsey is regarded as a rule that governs an aspect of the trust relationship, then one would expect to be a rule which would be recognised and followed in Guernsey.
The main difficulty that I have about that is that it assumes, this is a submission you've already made, that Section 42 is about the trust as opposed to the trust's relationships, legal relationships with third parties. And that essentially begs the whole of the point that you're arguing to that head. We've got to assume you're right about Section 42 in order for your submission about Section 65 to make any difference.
One has to assume that it's about the relationship between the trust, the property, and third parties. Yes, I do say that it is Section 42 is a provision about that. After all, the definition of trust is itself one which is defined by reference to property. And it's not simply about the relationship between the trustees and the beneficiaries, as appears from the definition of trust in the Guernsey context. It's about a relationship between the trustee and the property in relation to matters other than the beneficiaries too, because, as we've identified already, once you accept the concept that the trustee is dealing with third parties in a representative capacity, ultimately the creditors have some interest, economic or otherwise, in relation to the administration of the trust property. And so that's why we say that in the Guernsey context, the relationship of trust means something wider than it does in the English context. So, on that basis, we submit that given the similarity between the legal effect of Section 42, subsection 1, and Article 32, 1A of the Trust Jersey law, it would be very surprising if the Guernsey court came to a different conclusion about what the position was when the Jersey trustee was dealing with a knowing third party from the position that would apply if the Guernsey court was dealing with a Guernsey trustee who was dealing with a knowing third party. The Guernsey court, in the context of a Guernsey proper law trust, would say that this trust relationship, of which the third party was aware when he entered into the transaction, governs the relationship between the parties. And we say that if that's the position the Guernsey court would draw in relation to a Guernsey trust, it would be very surprising if it drew a different conclusion in relation to a Jersey trust, where the Jersey trust is treated under the Trust Guernsey law as being governed by its proper law, the law of Jersey, and the law of Jersey includes a provision to the same effect in Article 32.
You might think that what underlies Section 42.4, the overriding the lex causae principle, might flow very much from the fact that the relevant trust is a Guernsey trust, rather than, for example, a trust where the proper law was English law and the lex causae of the contract was New York law. In which case, does your theory that what's good for Guernsey trusts is good for all kinds of trusts survive in that context?
Well, my lord, I would submit it does. I'd submit that it's true that the Jersey statute hasn't spelt it out in the same way. And that may be that it's because it came first in time and the Guernsey statute was later. The Guernsey Court of Appeal took the view that Section 42, subsection 4 of their own Trust Guernsey law was merely clarificatory of what the position would have been anyway. And that may be linked to the conclusion they reached, that where a knowing third party is dealing with a trustee whose proper law is the law of Jersey, and where there is a provision to the effect you find in Article 32(1)(a), the knowing third party has to accept the status of the trustee and the limitation on his liability that flows from that status under the proper law governing his trust. So we respectfully submit that Section 65 is a rule of private international law, which has the effect that the Guernsey courts will look at the law of the Jersey, the governing law, including provisions in Article 32(1)(a) that are to the same substantive effect as Section 42(1). Can I just
you say they're to the same substantive effect, same reason as the Court of Appeal, namely that subsection 4 is implicit in the Jersey law?
No, my lord, because
otherwise
Section 42(1) is to the same substantive effect as Article 32(1)(a).
So, well, if Section 42(1) can stand by itself, you don't need subsection 4. Indeed, subsection 4 is probably on a false basis because it tends to confine the scope of the section rather than make it universal.
Well, my lord, it respects party autonomy in the way that we discussed this morning. It is possible.
Because unless the terms of the transaction.
Because you can have an express provision that the trustee will accept personal liability. Can I just complete this look at the Guernsey law, just to explain how, in practice, these matters are likely to be dealt with? Going to MS 20391, this is part 4. These are provisions of general application, and they apply to a Guernsey trust and where the context admits to a foreign trust. And then Section 69, this I hope gives the answer to my Lord Briggs about what the creditor would do in a case of the kind that we have here. Any person mentioned in subsection 2 may apply to the Royal Court to make an order in respect of, and Roman 1, the administration of a trust. And then 2, a trustee may be directed to make payments, and there may be directions in relation to any trust property. One finds all that in subsection 1. And then in subsection 2, an application under subsection 1 may be made by a variety of people. I think the procureur is like the Attorney General, trustee, settlor, beneficiary. The person described in section 32(2) is someone called...
You've got to get squeezed within G.
We do, that's right. That's with the leave of the Royal Court, any other person. So the creditor has to apply to get leave to bring his claim.
I mean, if Section 42 has the effect that a creditor can bring a direct claim once he's got a judgment against the trustee, against the trust assets, you'd expect a creditor to be included in subsection 2 expressly.
My Lord, it may be that it's dealing with a situation where it's necessary to take enforcement proceedings. I mean, after all, where you get a judgment and there are sufficient assets, the trustee may simply pay the creditor. The problem arises where the trustee has not paid the creditor. And in those circumstances, there may be this need for a filter. I mean, in England, too, you would bring special administration proceedings as a judgment creditor against a trustee. You'd only do it if you were in the position that the trustee had not paid up. You'd have to issue proceedings. And it's true that there's a difference and there's a filter. My Lord, I'm not sure that makes much difference to the analysis of what the creditor does.
Would you have to enforce your subrogation right at common law through an administration action, or could you do it
My Lord,
directly?
yes. I think you do, yes, my Lord, because what you're doing is you're claiming, you're saying that the trustee has a right of indemnity. That depends on the state of account between the trustee and the beneficiary. And therefore, you can't do it without joining in the beneficiaries in an administration action. I think there's authority. I think there's a case called Rawlinson, which we mentioned in our written case. So, my Lord, in summary, we submit that the Trust Guernsey law contains rules of private international law that govern this case. And therefore, the Guernsey courts is obliged by Section 65 to apply Article 32, 1A of the Trust Jersey law because, as is common ground, Thorson and Glenalla knew they were dealing with the trustees. And this means that there are matters which are regulated by the trust law of Jersey under the regime, the statutory regime which governs the relations in Jersey between not only trustees and beneficiaries, but also trustees and creditors. Well, in this case, what happened, as I pointed out, was that there was a claim against each of the three companies, Thorson, Glenalla, and Oscatello, and then a claim that the claims could be satisfied by recourse to the trust assets. That's how the BVI companies brought their claim, and ultimately that's the effect of the order which the Guernsey Court of Appeal has made. The claims for 80 million and 78 million have been upheld. There is judgment for those sums. And now the BVI companies have got to go through the process of enforcement through the administration action. Now, can I turn to a linked submission, which is based on the what we've called the status of a trustee in Jersey, or status of a trustee in Guernsey. My Lords, we accept that neither statute creates a separate legal entity as such. It's not a trustee, is not a different person. But the Trust's Jersey law has created a regime which governs the way that trustees hold their trust property. And it governs both the relations between the trustees and the beneficiaries, and also the relations between the trustees and creditors, because that is the effect of Article 32 or Section 42 in Guernsey.
Is it enough for your purposes to say it's created a regime as opposed to altering the legal character in which a trustee acts when he is litigating on trust business?
When he's transacting in trust business?
Yes.
I'm sorry. Well, Lord, I'd submit it does, and it isn't necessary that there's a separate legal entity.
Well, I see the force of that, because there may, the position is surely that in English law, all that matters is you identify the person you can sue, and that person must be a legal person, natural or artificial. One possible view of Article 32 is that it is dispensing with that requirement, and that without creating an extra legal personality, an additional legal person, what it is doing is recognizing that the same legal person may sue in two distinct legal capacities, and never the twain shall meet. Now, is that what you're submitting?
I'm submitting it goes further than that. I'm submitting it achieves what your lordship's described, but I'm submitting it goes further.
In what respect does it go further?
Because it's the reference to the words, the claim shall only extend to the trust property.
That appears to be a consequence of the fact
My lord,
that
yes.
it's as trustee.
My lord, yes, but it does create, therefore, a limitation on the liability, and also on the. It both protects the trustee's personal assets, but it also creates a limit. It says the limit of the claim is to the extent of the trust property, and that means what it says. Can't go further than that. And your lordship mentioned yesterday the Limited Partnership Act, and we see a useful analogy in that sort of case. Your lordship, I'm sure, is aware that under the Limited Partnership Act of 1907, there is a special sort of English law partnership, which is not a separate entity, unlike in Scotland, my lord.
Well, that's why the 1907 Act was generally regarded as fairly useless, because it had no application outside the UK or the English jurisdiction.
Well, my lord, what it did was to, as your lordship will recall, to distinguish between the position of the general partner and the limited partner. The limited partner, it said, was not liable beyond the amount of the capital that he put in, save where he had intermeddled in the business. He had to remain a silent partner, and the partnership had to be registered. Now, my lords, so it made as a matter of ordinary common law, your lordship will be aware, where partners carry on business together, they're jointly and severally liable for all the debts of the partnership.
Yes, but I mean, a foreign court would take the view that the rule of mutual agency, which the 1907 Act did not disturb, meant that the liability was assumed by all the partners, and that the limitation was not enforceable as a matter of public international law outside an English court.
Well, my Lord, so far as I'm aware, that we're not aware of a decision to that effect.
No, neither am I, but I think that would be the effect.
In my respectful submission, where there's a substantive provision of English law, as it was, which says that the limited partner is not liable for the debts and obligations of the firm. It's a strong thing to say that one could ignore that provision just because the partner, the general partner, has entered into a contract governed by another law. And that's
essentially what happened in the National Bank of Greece litigation. That you can't shed a liability under anything other than the proper law, but you can assume one.
Well, in the National Bank and Greece litigation, there were pre-existing debts. They were undoubtedly existing obligations. And the legislation in Greece had the effect of purporting ultimate discharge these liabilities. And it was said that subsequent legislation of a foreign law could not interfere with existing rights under the contract whose proper law was English.
If it had been previous, would the result have been any different?
Well, my Lord, the reason for the rule may be a different one, because one has to hypothesize about what the position of the parties would have been if they transacted after the Greek law had come into force. After the Greek law had come into force, they would know what the position was, and they would have to make a decision as to whether or not to transact, and whether or not the Greek law could have an impact on their transaction. The reason why those cases are, with respect, irrelevant in our case is that where the trustee deals with a knowing third party, they enter into a transaction. From the moment they enter into the transaction, the knowing third party is aware that the trustee is not, under the governing law of Jersey, personally liable, but only transacting in a representative capacity. So this is not a case where the Jersey law is operating subsequently to affect an existing transaction. It depends on the state of knowledge of the parties at the time they enter into the transaction and when they define their legal relations. And it's for that reason why we say that the cases that learned friend put forward in support of their discharge rule are dealing with a completely different situation. They're dealing with a case where there is a pre-existing contractual obligation of the defendant. And then some event of foreign law purports to discharge the defendant's obligation, and the defendant seeks to rely on it.
But I see the distinction, but how does it work if in the National Bank of Greece cases there'd been a Greek law which said that no matter what the governing law of this contract is, no Greek bank shall incur liability of more than $1 million on any contract? That would have been regarded, wouldn't it, as irrelevant as the subsequent Greek law which purported to discharge the National Bank of Greece?
Well, my Lord, it depends on the character of the law, doesn't it?
Well, that's why that may not be the point, therefore, whether it's pre or subsequent. The point may be you have to go as far as Lord Sumption was putting earlier, namely to say that in some way the trustees, for the purposes of situations where they're known to be acting as trustees, effectively acquire an additional identity, a corporate identity, a bit like a corporation soul, and they only commit their assets. But that's what I'm suggesting, that it's not a question of pre and post.
Well, my lord, if one looks at it in terms of how it should work as a matter of fairness and policy, with two parties proposing to enter into a transaction, the knowing third party is aware that this restriction exists. And if there's no express provision to the contrary in the contract, then the third party is not going to be able to recover against the trustee personally, and there'll be a limitation to the extent of the trust property on his claim.
Slightly circular, because the knowing third party might take some advice from a firm of solicitors which said that this is irrelevant if it's an English law contract.
He might be wrong.
And he might,
Might be wrong. Yeah.
A very similar problem arises in relation to the law of illegality. There are a large number of cases in which people have entered into agreements which it is known cannot be lawfully performed by one of the parties under the law of his own domicile, e.g. exchange control rules is the normal context. Nonetheless, the courts have said that illegality under the law of the one party's domicile is entirely irrelevant if it's not the proper law of the obligation.
my lord, my recollection, and I know your lordship has very much greater knowledge than me about this, but my recollection is that if one looks in Dicey, Collins and Morris, Rule 3, this is dealt with as foreign exchange control, comes into a rather special category, don't they? It's
Well, there are limited statutory provisions, but at common law, I think that's the position.
my recollection from looking, I think it's at paragraph 5-30 of Well, my learned friend referred to foreign exchange regulations last night, so I looked it up. But Rule 3, you may recall, is the rule which deals with the way in which the English court won't enforce foreign revenue laws or penal statutes. And interestingly, in this context, so far as I can recall from what I read last night, the foreign exchange control regulations were treated in that same bracket. So I'd respectfully suggest that it's a different rule of private international law that we're concerned with in that context.
I'm not sure that that's right, because clearly public laws are not generally enforceable for public laws of other countries in England. But the basis of the law of illegality is rather different, and the same principle would apply there as applies to any other form of illegality, whether relating to exchange control or not. Illegality under a law whose only connection is with the domicile of one party is irrelevant.
My Lord, I'm afraid I may need to think a bit more about that example Lordship's given.
The truth is you have to find a relevant connecting factor to make A applicable. And I think a moment ago you were saying, well, general fairness, if you know that trustee is trustee, well, you must also be assumed to know about the law, trust law of the country of the trustee, and you take it for what it's worth, especially if you're a Guernsey operator when they have something rather similar in their law.
You take your counterparty
Yes.
as you find him.
But the difficulty with that is that unless the counterparty has ceased to be an individual for present purposes and acquired some different capacity, when I recognise that he falls into a different conceptual bracket, I have a bit of difficulty in seeing how all those things are anything other than vain arguments against the proper law and unsuccessful. So you do, but I think you do go that far. You do.
I do go. Yes, I do.
Yes,
Yes, I
yes.
do. And I was trying to develop a few minutes
a further
ago.
argument. Yes. Sorry. Well, we don't want to.
No.
We'll stop pushing you.
I was trying to develop an argument about the limited partnership position.
Yeah,
Where-
yes, that would be helpful. I mean, is there any authority? I'm very surprised if we haven't had.
There is
comment.
one very unsatisfactory authority, where it was all, where the Court of Appeal, I think it was Sir John Donaldson.
Is this Sir Johnson, Massey, and Baluch?
Yes, decided that the relevant rule in, I think it was Jordan, was merely procedural. But he said that if it had been a and he had good reason for, if I may say so, it was implicit in what he was saying, was that if there was a substantive law of Jordan which limited the liability of someone who, in this country, would be viewed as a partner, then that would be a reason for respecting that limitation.
Can you give us the reference?
Could I ask my?
Well, it's a case which has aroused some academic disquiet.
Sorry. I got Johnson Matthew and Ahmad Alouche.
We wrote a report on limited partnerships, I think, in the Law Commission, but
I think I remember.
There's very little case law on limited partnerships.
Discuss the IPO.
My Lord, yes. Could I just, sorry, the Ahmad Johnson Matthew, it's 23282, volume 9 of the Authorities Bundles, tab 98.
23282.
Yes. If I may, the limited time I've got,
Yes, please.
could I try to keep going then?
Right.
My Lords, I was dealing with I was trying to explain what might happen in the context of a limited partnership. A claim, let us imagine, a contract governed by a foreign law between third party and the firm. And under the Limited Partnership Act, as a matter of substance in this country, not procedure, the limited partner is not liable further than the capital that he's contributed to the firm. And the general partner is liable for all the debts and obligations subject only to that point.
German law, they avoid that by making the general partner a limited company. And I'm surprised that nobody's ever tried to sue the limited partners in relation to a German shipping company. But I don't know of any authority on that.
I don't at the moment.
No.
The point I was making is this, that the English statute, as a matter of substance, says that in those circumstances, the limited partner is not liable generally for the debts and obligations. By contrast...
They will only ever have been incurred by the general partners, won't they? So that
in the name of the firm,
that the contracting party will always be the one or more of the general partners. Because the Limited Partnership Act has very strong restrictions on the limited partners doing anything or binding the firm.
But the rules about a firm name apply equally to a limited partnership, so that the contract can be in the name of the firm.
yes, and all the partners, limited or not.
I think the general partner does commit the firm,
Yes, including
but under English domestic law, the effect of that is that the liability of the limited partner is limited, notwithstanding that he is, on that view, a party to the contract, because no additional legal entity was created. I mean, this is one of the reasons why the 1907 Act was so unsatisfactory and was replaced wholesale by more recent legislation.
But it raises acutely a point that if the third party sued the limited partner in England, saying the governing law of this contract is a law where we don't have limited partnerships, under our law, the law is the same as the common law of partnership in this country, in England. The general partner and the limited partner are carrying on a business together. Therefore, the limited partner is jointly and severally liable for the debts of this firm. Now, in our respectful submission, the courts, as a matter of private international law, ought to respect the statute which regulates the relationship between the general partner and the limited partner. Because you know you can find out you're dealing with a firm, the limited partnership has to be registered and so forth. In the same way, we say, in this country, in the context of a Jersey proper law trust, like the Limited Partnership Act, it distinguishes between the rights, the internal rights between the trustee and the beneficiary, on the one hand, and the relations between the trustee and third parties on the other hand. And we would say that in both cases, where that is the legal code or regime that governs the relationship between the persons within this recognized statutory code, let's say trustees, beneficiaries, as a matter of private international in principle, that status, that code should be respected.
I mean, you put a lot of weight on the word governs, I think, and you're looking for what the word governs directs you to a regime which covers that particular type of a relationship. And in the Limited Partnership Act, that would be, you would say, for Guernsey law, what governs that relationship, I suppose. And here you say the trust, Section 32 is part of the governing regime. Yeah. So it's not about status, it's about the regime.
But it's about both, my lord, but I recognise it's...
Well, it's just you're getting away from general rules of private international law and looking at the particular way it's dealt with by the Guernsey statute. Is that right?
Yes, my lord. But I think there are two facets of it. There's the analogy, as I say, with other sorts of legal relationship, where you don't have to have... It doesn't have to be a separate legal person, we would say, that gives right to the respect for the legal relationship. Another example we've given is the position of the executor, who, under our principles, is liable only to the extent of the assets that he acquires from the deceased. He's not liable beyond those where he's sued by a creditor of the deceased.
Well, he's merely an agent, isn't he, the executor, or is that wrong?
No, my lord, he isn't. No.
He has the assets vested in him. Has the assets vested?
He has the assets vested in him.
Yeah.
So it's quite a close parallel with the
And the
trust.
liabilities?
Sorry?
The liabilities are also vested in him, are they?
The position is that he, it's not quite like the sort of continental civilian system. The position is that he, if he acquires the assets, he becomes subject to an obligation to discharge the deceased's liabilities to the extent of the assets, but not further.
But that's on the footing that he is not personally under the liabilities. It's simply a duty as to the use that he is to make of the assets.
Your Lordship is right that it's recognised that he has a representative capacity. And it's on that basis that our law says it's unfair that he should be made liable beyond the extent of the deceased's assets.
We will sue him or her as executor of, don't you? And, but that doesn't quite answer the question, where are the liabilities? They must be vested still in someone, you presumably say.
Well, by process of succession, I suppose. Yes, they pass under, I suppose it's a law reform.
Yeah, so it does fit your bill.
Yeah. So, well, it's for those reasons that we say that there are other examples, not just the trust laws of Jersey, Guernsey, 32 US states, where there is a regime which defines the nature of trusteeship. And it defines the nature of trusteeship not merely as between a trustee and beneficiary, but also it governs how the trustee may or may not be liable in dealings with third parties. And we say that that statutory regime, which applies in these various jurisdictions, falls to be respected as a matter of private international law, and that there's nothing that is unfair or interferes with party autonomy as a result of respecting these regimes. And that is because at the heart of these regimes, they distinguish between the knowing third party and the unknowing third party. Once you know once as a third party you know you're dealing, about to enter into a transaction with a trustee, you can define your obligations and relations as you choose. And the position is the same, we would say, with a limited partnership, with a company. You need to ascertain, when you're dealing with when you're about to enter into a transaction with a company, what are your rights going to be to recover, ultimately, if it's necessary, because the counterparty doesn't meet its obligations. And that's why we say, as a matter of private international law, the courts should recognize that when dealing with counterparties who are not individuals, it is necessary to take account of that and respect the regime which applies to those counterparties, and not simply to say they should be equated with private individuals for all purposes, including the rules of private international law. So your lordships have probably seen in the course of the judgment of the Guernsey Court of Appeal a reference to a case called Risdon. Yeah. And we accept that there the debate was not of the same kind that we're having here. But if my learned friends were right about the law of the obligation prevailing over the law relating to the entity with which the outsider was dealing, that case would have been decided the other way. Can I refresh your memory of the facts? It was an English company which was authorized to carry on mining business in California. And it was a limited company of conventional English kind. It carried on business in California and incurred trade debts to Californian suppliers under contracts in California, which it's to be inferred were governed by the law of California. Under the law of California, the position was that if as a matter of statute, if the company failed to pay, then the third party could go against the shareholder. And the English Court of Appeal said, no, that can't be done. But if the rule of private international law is that
well, what they actually held was that the company and its directors had no authority, as a matter of agency, to bind individual shareholders, given that in England they were separate entities.
My Lord, you're absolutely right, if I may say so, but I respectfully submit that if the principle had been as wide as my learned friend contending for, then the governing law of the obligation in California ought to have determined the outcome of that case.
Well, isn't there a distinction between an issue as to whether some person other than the contracting party is also liable, in that case the shareholders of the English company, and a case where the question is as to the extent of liability of the person who has actually contracted?
It's a different case, my Lord, I accept that. But it remains the position that if you look at the law of obligation, you can get through the company to the shareholders. Now, I mean, let us take an example of a contract with an unlimited...
Unless the shareholder has bound himself in some way, you can't.
Just not the law of obligation.
The problem is if the shareholder is a different person, he's not bound. Yeah.
Well, can I pose a contrast, which is the case of the unlimited company, where the unlimited company enters into a transaction with the third party. In the unlimited company, the member may, in the event of insolvency, find himself liable there. So, in those circumstances, it's not a case of it being a only if. That risk is always there in the case of the unlimited company, that the member may find himself bound by the transaction.
Well, what that illustrates is that if you contract with an association of any sort, the proper constitutive law of that association will determine what it means to contract with the XYZ association, whether the XYZ association is a separate entity, whether it is a partnership, whether it is a group of people like a pre-1857 joint stock company, and so on. Once you distinguish between that law and the law of the obligation, which is not concerned, it may identify the XYZ association as the contracting party, but it is concerned with the question, what is the extent of the liability? And that's a completely different question. Well, you've just, both the cases that you've referred to, Risdon and the example of an unlimited company, are essentially illustrations of exactly the same rule.
Well, look, what I had in mind was this: where the contract is made with another party, whether it's a trustee or any form of company or any form of partnership, the law of the obligation will tell you what is the amount of the claim, what you can get judgment for, as in this case, what the debt was. But you have to look beyond the law of the obligation to the law, Your Lordship used the phrase, the constituting law of that party, to see the extent to which you can go against, the extent to which you can enforce.
See what it is, certainly to see what it is, but when you go to talk about the extent to which you can go against it, that's a slightly wider.
I'm sorry, I didn't put it. It's about, you have to look at the law of that constitutes the legal relationship to identify what you can do with your judgment for 80 million.
To identify what's the relevant obligation, who the relevant obligation is owed by. If it's a partnership, it's owed by all 50 partners. If it's a company, it's only owned by the company. Both of those questions are decided by the constitutive law of the partnership or company, as the case may be.
My Lord, yes.
Well, shall we resume the discussion at 10 o'clock, my Lord? You're not feeling too aggrieved by the loss of the 10 minutes.
So I'm sure I can make it.
Can we adjust it?
I'm sure I can make it. Thank you.
10 o'clock.